terabytes and say, have at it and go find it. If you have it and I've told you what I'm looking for, you got to turn that over to me in that form.
All right. So I think we're spinning our wheels at this point. Mr. Rafferty, obviously on that specific point that they have to then kind of point to this and that and respond to discrete evidence requests, make that a part of your motion, because I'd like to see the case law on it, and we can take that up at the appropriate time. In the meantime, I think in order to, there's a lot that needs to be done between now and October 23rd, and I think the best use of our time isn't being in court here talking at each other. I think that acknowledging an email, replying back to it sometimes could prevent us from being here as often as we may have to. So to that end, I would encourage everyone to keep the lines of communication open, and we'll take the motions up at the appropriate time. So anything else that we need to hear today?
If I may, I just give you a copy of the case law.
Okay. And this is something you already provided to the defense? Okay. All right. And well, when it comes to scheduling, I wanted to address this grand jury issue early on in the case, since there would have to be some follow-up investigative work. But I don't think we would need to make this a weekly recurring thing for now. We could wait until the discovery deadline passes and the motions deadline passes and then start scheduling the rest of these hearings. So that's the plan.
Your Honor, on that point of scheduling, if it's possible, if we have to have a hearing next week, could we have it Monday, Tuesday, or Wednesday? That's my request.
I know next week I'm presiding, and right now Wednesday looks mostly clear.
Thank you.
So that could be a date we could shoot for if there's some kind of emergency that has to be heard.
Thank you.
And we could even try, Mr. Roy.
Oh, sorry, I was changing topics. Are you done?
Oh, that's fine. Yeah.
With regards to the scheduling order, I think there was a September 20th deadline, and traditionally 1716 4B1 says once we get the discovery, we have 10 days to respond.
Mm-hmm.
I guess if we got it today, could we have our 10 days starting now for me to respond? Because I don't know what to turn over to them until I see what they have. That's traditionally how it works, but I know we're on a compressed time schedule, because if we all turned it over on the same day, it wouldn't really make any sense, because I'm not sure what it is I need to, address as far as our case goes.
Well, I hadn't heard that one before. I think generally the intent of the scheduling order is that there is a mutual exchange by that date, and that if there is then supplemental discovery because it's newly discovered or newly becomes relevant in good faith, then it gets turned over within 5 days, I think is our general guideline there. So I think you, based on the indictment itself and the arguments we've had so far, have a pretty good idea what the state's case is against your client. And so I would think that you could turn over the bulk of your discovery by that deadline. If there's some follow-up that needs to be done and the state's unsatisfied with the timeline of when it's turned over, then they'll file a motion and we'll hear it.
I just don't want to be bad faith issue. I don't want to pay experts if I don't need them based on what the discovery says and what witnesses they have, since we've got it today. I need to respond.
Well, experts will be classified differently. I think we also have a trial management order where we say experts are supposed to be identified and summaries of their reports. I believe it's 14 days. It might be 7. We'll take another look at that, but that's in a different category.
Traditionally the statute actually says once government gives you discovery, you have 10 days to do it, or X number of days before trial. I just want to be able to go through however many terabytes there are, so I'm not sending the same thing they're sending me and wasting a bunch of time. There's only 3 of us on Mr. Chesebro's side. That's all I'm saying. There's no bad faith issues. I kind of sort of know what I need, but if they're going to call 150 witnesses, I need to figure out what the rebuttal is, because I figure I'll sit through 140 of them and maybe cross-examine 10 in the trial, and so I'll just watch movies or something. But, in the interim, I'm just trying to figure that out, and so...
Understood. Well, obviously, like I think you've kind of already alluded to, if after this discovery deadline is passed, then you've got a smaller batch that you think now needs to get turned over, then do it, and it should be still I don't know about well in advance, but it should still be enough in advance.
It's just not new, and I didn't want you to say...
Sure. And if the state has a problem with it, then we'll take it up, and then we'll just have to see what the arguments look like.
With regards to the more substantive motions, being the supremacy clause, the RICO, the justification, and there's a First Amendment and an anti-SLAPP type motion coming as well, I think you've said that they would probably be required to write it. I'm going to have witnesses for that, so if we could set that out so I can fly the people in as far as that goes, that would be good.
Okay. So at the case management hearing, we're going to want to go into how many witnesses, how long you think each hearing is going to take, and then we'll start setting some dates.
And then the last thing is, if depending on how some of the rulings go, there may be some interlocutory requests for if you ought to want to screw up the jury selection or whatnot, because that stops the tolling or tolls the speedy trial. Just letting you know, that may be an issue because some of these are somewhat case dispositive, at least the RICO and things like that. So,
Understood. We'll take those up as they come.
right.
Anything else?
Thank you, Judge.
Thank you all.
Thank you.